when jurors view someone who they perceive to have committed a selfless act, they view that person as a hero. If they view someone as doing an act that is selfish, they view them as evil potentially, and it creates this moral outrage in them. So what we do in framing the case, really through the opening, is we create a situation where the villain in the case is naturally, we're going to tell a story where they make a decision that is selfish. And that's going to create some emotion in the jurors where they feel like that is morally wrong, even if they can identify with it. One of the things I encourage is that that lawyers allow the jurors to have some empathy for the villain so that they can perspective take and understand and give some credibility to the story. But we create this selfish act, which puts the jurors in a position where now they're like, they've got this built up desire to want to help, to fix it, to fix the problem.
Welcome to the Free Lawyer Podcast. I'm your host, Gary Miles. The Free Lawyer Podcast is designed for the lawyer, entrepreneur, or professional who is in some way unfulfilled, stressed, or stuck and is looking for something better. We will discuss various blocks that limit us from achieving the personal freedom that we all desire but have not yet fully experienced. And we will give actionable steps to free yourself from them. Are you looking to achieve a new level of success? If so, this podcast is for you. Hey everybody, thank you for joining us today for today's episode of The Free Lawyer. This is going to be a dynamite episode, particularly for those of you who ever do trial work or ever the courtroom, because we have an amazing guest who's going to show you how to do that better. And before we get started, I just wanted to thank you all for your support of this podcast. It keeps growing, and I tell you, it's so fulfilling to see how many people listen and tell me they like it. And one ask I have of you, if you like what you hear, I would love you to give the podcast a rating and review, because that helps it get seen by more people. So thank you for considering doing that. Our guest today is Keeley Blanchard. Keeley is an incredible trial attorney in her own right. She's tried over 70 cases, very, very successful. And her passion is showing us how to do a better job in the courtroom, how to tell a story to the jury that helps us get a more favorable result. And she spends her life now helping trial lawyers do better at their craft. Keeley, how are you today?
I'm so good. And thank you so much for having me, Gary. I'm really excited because I am a listener. I found your podcast a few months ago and am faithfully listening. And I'm really excited to talk to you because I think you do such a great job with this podcast. So
thank you, Keeley. I appreciate that. So Keeley, just for the audience who's listening, who doesn't know you as I do, share with them a little bit about your journey as an attorney and how you shifted to what you do today.
Yeah, well, I am really a small town lawyer. I live and work in a community of about 10,000 people, but I've been doing trial work. I spent 18 years as a trial lawyer doing criminal defense and mostly civil rights work. I have also done some plaintiff's work, like the occasional dog bite case and that sort of thing. And in 2015, I started teaching and ultimately really developed a passion for that. And in 2019, I was hired to create a grant-funded program that provides free training for public defenders in Michigan. So I started to transition to doing teaching part-time and trial work part-time. And then ultimately last year, I started to make the jump over into doing mainly jury consulting and teaching. And so now I'm actually not doing any trial work and am doing jury consulting and teaching full-time.
And that's so important. I've done trial work for 45 years and I've tried a lot of jury cases, but I began in an era where there wasn't really such things as teaching people how to be trial lawyers. And I learned from my mentor, who was a very, very good civil defense lawyer, but I never had that training that you make available to people today. And so I want to thank you for that, because often I talk to a lot of young lawyers and they're uncertain and they're confused, and their firms don't give them much training and mentoring, because in the billable world, if they take a trial attorney to teach a younger trial attorney how to do it, that's two people who aren't billing for that time. And so many of them feel lost and confused about, what do I do in the courtroom? Or even, how do I take a deposition, whatever it might be. So I want to thank you for doing that. What was the moment? I mean, you were a full-time trial attorney. You tried a whole lot of cases in your young career. Of course, to me, everyone's young, but you tried a lot of cases. What was the moment or the experience that made you decide, instead of just trying cases, I want to teach people how to try cases?
So, I wish actually that this was like a warm and fuzzy story, but I think
it is what it is, right?
Yeah, the reality, as I was thinking about this, I was thinking back to a few episodes ago of your podcast where you shared some of your experience and some of the hardships that brought you to this place. And that's really kind of a part of what brought me here. I've always been a person who is just sort of constitutionally unable to separate my work life from my personal life. And I have always, as a trial lawyer, really invested in my clients and their lives and really cared about them, loved them. And I really fell in love with teaching when I started doing it in 2015. And I was on that path of really loving it. But I also love trial work. I love being in the courtroom. But I had an experience where a juvenile client that I had worked with for many years and really ultimately sort of gave him a second chance at life, had he had actually just gotten out of the system completely, and he had reached out to me and said, hey, I'd like to ask you some questions. We set up a meeting. And of course, as busy trial lawyers have things happen, I got busy. I said, hey, I'm going to have to reschedule it. And that night, his grandpa got in contact with me and let me know that he had actually gone out and he had shot two people and then turned the gun on himself. And it was, for me, an experience that just broke me. I felt very much like it was my fault. I became really depressed and had to spend a lot of time trying to deal with and cope with what had happened, not only with sort of missing that meeting with him that day, but also just the work I had done with him for so many years that, he still went out and harmed someone else, and ultimately someone I cared about very much lost his life. And I was at the point where the stress of taking on the emotional load of really loving and caring for my clients in that way was something that I didn't have the bandwidth for anymore. And I needed to find a way to stay doing the thing that I loved the most, and still helping people, but give myself a little bit of a break and a separation from that closeness with the clients.
Wow, that's a very moving story, and I can still today hear the emotion in your voice as you reflect on it. A lot of people talk about compassion fatigue. One of the struggles we go through as lawyers is we care for our clients so much, and we really want to help them and serve them. And one of the hard things about doing any sort of trial work, even if it's non-jury trial work or family law, is our investment in our client and their success. And things often work out right, and you've been very successful, and sometimes they don't. And it's very, very hard for us to handle that. I know I won many more cases than I lost, but I didn't appreciate my wins as much as I should have. I sort of expected them.
Yeah.
And that's one of the things I always struggled with, expectations. I expected to win. And then when I won, I didn't particularly enjoy it because I expected to win. But when I lost, it was crushing. And I learned I had to really change that perspective. But you have a real heart, a deep giving heart, and that must have been very, very difficult. So you decided to move into teaching trial work. And I know a lot of what you talk about is storytelling, and you've kind of explored the science behind storytelling. Tell me about that, what that looks like, and what caused you to do it. Like, I wouldn't have thought there was a science behind it. I just thought, I understand the concept, telling a story is better, but you've gone much deeper, haven't you?
Yeah, well, part of my personality is that I sort of go overboard on everything that I do. So if I do something, I'm going to do it all the way.
I can
And
relate to that.
yeah, I bet you can. Uh, so the thing that really got me into storytelling was I was teaching for the Trial Lawyers College, and they became involved with the Moth Community Program. And the Moth is also a podcast, they're a radio show. They have shows all over the country. And it's a great storytelling resource for anybody who is looking for storytelling resources. And so their community program came in and began to work with our trial lawyers on storytelling. And I started to see like, oh wait, there's a structure to this, and there kind of is there's a science to this. And so it just sparked my curiosity. And when I got hired to lead the grant funded program in 2019, I was suddenly blessed with the ability to get paid to create curriculum and to do research on how to do this better. And it was such a blessing for me because I started to go down this kind of rabbit hole of, wait, there is a science to this, and there is so much science to story and how people process information. And so it's just been a journey for me, and one that I'm going to be on probably for the rest of my life because I find it just incredibly interesting. And the more information about the science that I consume, just it's amazing to see you be able to take that science and put it into action and really see it work. So it's very exciting.
So briefly, what is the science when you keep using the word science? Because I think of it as a good tool, but I don't think it necessarily of it as a science. So explain that.
Yeah. So when we look at the way that people process information, we are processing very little information consciously. Like we have something like 11 million bits of information sort of coming at us every single second, and we're able to process like the smallest tiniest fraction of those things on a conscious basis. And so our brains are using our prior life experiences and our life experiences to really start to construct a story framework in our brain to process the new things that are coming at us. And so when we understand that, when we can understand how people are processing information and the frameworks that they're using to process that information, we can start to structure our story in a way that can meet some of that framework where they're at. And sort of we can use story to funnel them to a conclusion as opposed to just trying to tell them something, like to try and give them a conclusion, which isn't very effective. We can take that and help them tell them a story that will help them decide for themselves that our story is the right one.
I know you talk about your signature story structure and that lawyers could use during the course of a trial for openings and closings. And presumably you could use it in non-jury matters as well. If you have a family law case, I suspect the same principles would apply. But what is a signature story structure, and how does it differ from traditional approaches of trying a case or making an argument?
Yeah, so I think the biggest difference between what I teach people to do and what lawyers are traditionally doing, particularly when we think about, criminal defense lawyers and plaintiffs lawyers, they have individual clients who they spend months and years sometimes learning their individual client's story. And so I think for a lot of lawyers, um the instinct is to frame a story using the client as the protagonist. And what I teach them is that we want to take our client out of that role as a protagonist. And the reason is that part of what the brain science shows us is that the people who are consuming the story, in most cases are jurors, are going to have certain expectations for how stories go. So especially in Western culture, what we see is that people have the expectation that a story is going to kind of follow the hero's journey. And what happens when we put our client in the role of protagonist is the jurors are looking at our client's decision making. And the question always in every story is the protagonist going to fix their flaw? Are they going to make the right decision that's going to get us to the place at the end of the story that is going to give us some satisfaction? And the reality is that our clients are coming to court because they don't have the ability to fix it themselves. And so when jurors are analyzing our clients' decision making, even if those decisions are really innocent, it's not going to give the jurors that satisfaction, and they are going to probably punish our client for it. And so instead, we remove our client out of that protagonist role and we put in the protagonist role the villain. And that allows us to put someone in the role who's committed a betrayal against our client and tell the story using them as the vehicle. And what that does for us is it puts the jury in a position where they analyze the villain's decision making throughout the course of the story. It creates some moral outrage because the villain's going to make the wrong decision. And now the jurors feel like they can come in and play the role of the hero, and they can come in and play the role saving our client rather than punishing them. So
if I understand right, the story that I would tell would be the story of the other party to the case,
absolutely,
rather than my own client.
Well, and it's not that you are telling their story. You're not telling the other party's story, but you're using the other party as the vehicle to tell your client's story. So you're still sharing your client's story. You're just changing the framing of the story to use the villain as the vehicle to get there.
So let's think about a personal injury case. I spent most of my career, 30 years, doing insurance defense work in the transportation industry. So my clients were truck drivers. And I don't know about in Michigan, but in Maryland, not a lot of people were naturally in love with truck drivers. And so, if my truck rear-ended someone on the Beltway and it was my fault and I'm defending it mostly on damages, the plaintiff might be blameless. The plaintiff isn't villain. The plaintiff's done nothing wrong. How do you take just a situation like that where the other party, it's hard to make them a villain and tell a story that would be helpful to the defense side of the case?
Yeah, absolutely. Well, I suspect that you did this pretty well because you won a lot of cases. But what we want to do is take away from, we don't, particularly in that situation, as you tell your story about your client truck driver, do you want the jury focusing on his decision making?
I certainly don't.
No, right? So if we start to tell the story using your client as the protagonist, the jury's going to be looking at like, oh, well, this isn't good. Like there's lots of decisions that were made. And so what we would need to look at is what is the way, particularly, let's say this is just a damages case. what is the way that we can frame this that is dealing with what's the betrayal in that they're asking for too much in damages, right? Is essentially what you're saying. And so who is the decision maker there? Like what is the betrayal of your client in that, yes, he did something wrong. He did something bad. He had a failure, but there's something going wrong on the other end of it in that they're asking for too much.
Right.
And so we're looking for who is the person that we can use to frame that story of essentially greed, asking for too much.
Right.
And so we can take and look at that, and there may be multiple people that we have a choice to use it. It might
The
be
lawyer, the doctor, the treating facility.
yeah. So there's so many different choices
So
there.
what's the difference between me, in our hypothetical case that we just came up with, making those logical arguments? The plaintiff is seeking too much money, they got too much treatment, the doctor, the lawyer. How do you turn that into a story? Instead of just me logically making that hopefully persuasive argument that you would tell me isn't as persuasive as if I did it in a different way. What's the technique of creating a story about those arguments we want to make in a case?
So we can take story structure, and one of the things that any of your listeners can do, you can go Google story structure, and you're going to get the same sort of graph that you'll see over and over again in a 5-part story structure, where you have a before, an inciting event, a central conflict, and then ultimately what I like to have the 4th and 5th pieces be is the decision of the villain to commit the betrayal, and then the impact of that decision on your client. And so we take that 5-part story structure, and we take the facts that you would sort of argue from a logical perspective, and we put a structure to it. And giving it that structure helps our jurors to be able to consume the information in a way that their brain can better organize and that they can better understand it. We can look at using that story structure to spark curiosity, to do things like foreshadow and keep people invested in the story, keep people curious through the entire story. And that's one of the big challenges that I think we all have, is getting people to pay attention. I mean, I'm sure you've seen through your career that attention spans are getting shorter and shorter.
Yes, they are, for sure. For sure. So, if I'm going to give a 30-minute opening statement, I've always believed in brevity for that reason you said. I've never understood lawyers who give a 3-hour opening statement, but that's just me. Is the story my opening 2 paragraphs of my opening statement, or does it end up sort of consuming the entire opening statement, if you know what I mean?
Yeah, that's a great question. So, you would be surprised to see most of the lawyers that I work with, I get them to give their opening statements in 10 minutes or less. And so we really try and bring it down to something, even in very complicated cases, we try and bring it down to something much more concise, because that's all the jurors really have the bandwidth to consume. And you would see that the entire thing is really all about story. I really encourage lawyers to set aside things like trying to, go over jury instructions. And, if we're going to do that, we need to weave it into the storytelling, and look at ways to do that. But I really think that we can set aside a lot of that, and we can relieve ourselves of the burden of feeling like we have to make those arguments. When we go in and tell a good story, that stuff can really go to the side, because it's so persuasive and so motivational for the jurors to hear that storytelling.
So the story becomes the entire opening, but the opening is much, much shorter than a lawyer would traditionally give.
Absolutely, which
That
is tough.
it is. It is tough, particularly because I get a little OCD or anal, and particularly in the closing, I want to hit every darn point I can. What about the closing where you have so much? You might be a 4-day jury trial, and you have a lot of evidence and a lot of witnesses and a lot of different issues. Same thing there, or has it become more comprehensive and cover more?
So again, I really try to help the lawyers that I work with bring it down to something that's in the 10 to 15-minute range for closing. And we really focus on storytelling with closing as compared to opening. Opening is the story of your case, closing is the story of the trial. But we mostly, when I'm helping a lawyer prepare for trial, we mostly have our closing written before we ever start the trial. And then it's a process of editing as we go throughout the process. But the closing follows a structure very similar to that of opening, but we're changing the content up quite a bit. And the closing becomes not about convincing jurors, because really we should have already convinced them in opening and delivered on it in the evidence that we presented at trial. And then closing is about empowering the jury to take the moral outrage that hopefully we've created for them and empowering them to go do something about it, to really give them some information about what they can accomplish by giving us the verdict that we want.
And what do you mean by that? Moral outrage, accomplishing something? I mean, I think of asking the jury for a verdict, a defense verdict, a plaintiff's verdict, a certain amount. What does that look like? Moral outrage and convincing them to do something.
Yeah. So one of the things that we see in going back to the brain science, and I can nerd out on this stuff for a long time. So the brain science shows us that when jurors view someone who they perceive to have committed a selfless act, they view that person as a hero. If they view someone as doing an act that is selfish, they view them as evil potentially, and it creates this moral outrage in them. So what we do in framing the case really through the opening is we create a situation where the villain in the case is naturally, we're going to tell a story where they make a decision that is selfish, and that's going to create some emotion in the jurors where they feel like that is morally wrong, even if they can identify with it. One of the things I encourage is that that lawyers allow the jurors to have some empathy for the villain so that they can perspective take and understand and give some credibility to the story. But we create this selfish act, which puts the jurors in a position where now they're like, they've got this built up desire to want to help, to fix it, to fix the problem.
I see.
And so closing is really about talking to them about not just the way that the verdict is going to impact our client, but it has these ripple effects, right? Every jury verdict has effects on way more people. It can have effects in our whole society. And giving them that information can really empower them to now look at this not as just I'm deciding this case sort of in a bubble for this one particular client. Now they're looking at it as I'm having an impact on the world, and this is going to be the result of my decision. It's going to ripple out and have effects on everybody.
That makes so much sense. I hear lawyers often ask juries to send a message, and that's kind of what you're talking about. And I see actually even in the clear liability defense case, how one could tell a story about the plaintiff but you trained public defenders. That was where you started, and that was where you did a lot of your work. Your client has assaulted some poor old lady in the street, hit her upside the head, and stole her pocketbook. How do you make that poor old lady who's been injured through no fault of her own, how do you make her a villain?
So it depends. I may not be making her the villain, right? The thing that I love about criminal defense is that it's always challenging, right? It's always an uphill battle.
Right.
And you always feel like you're kind of that David versus Goliath because the government has so many resources and so much power. But there's always a betrayal of your client that you can find in the story. And it may not be that the old lady who was assaulted did anything wrong. What it may be is that the police officer who did the lineup did it in a really unreliable way. And that's a betrayal because now they've got the wrong guy because the police officer didn't follow the procedures that we're supposed to follow in order to get a reliable identification.
Right.
Or yeah, it may be
whatever side of your case you're on, even the case that seems extremely difficult, you look for that one flaw in the other side's case, and you make that person who's responsible for that flaw the villain in your structure.
Absolutely. And sometimes we have cases with lots of choices.
Sometimes we do. And you have multiple villains. Do you still just focus on one?
Yes, for the most part. It's not impossible to have a case where it feels like you should be telling, there's villains all over the place. But part of what we need to do when we're telling stories to the jury is we need to take these big piles of facts. Like, I can imagine you think about the cases that you've worked on with just massive amounts of discovery that we do. You take these massive amounts of pieces of information and have to make it digestible and understandable for somebody who's not going to have the years that we've had to work on the case to digest that information. And so sometimes getting into too many villains can really be problematic because it makes it more difficult for the jurors to understand. So while it can be done, I don't encourage it because I think it's a very challenging thing to do. And it's probably something best reserved for the very unique case.
Keeley, I tried my first solo jury case about 40 years ago, and I sure wish you were around then to have taught me storytelling then. And now I'm not sure that I'm ready to take on my next case, but part of this makes me want to try that. What is the most difficult part for your trial lawyer students to learn, or their biggest mental or emotional obstacle in adopting the storytelling structure for their cases?
So I think the biggest obstacle is editing. Really, like, it is that we as the trial lawyers do spend all of our time trying to uncover every single thing about the case, every single fact that we can find about it. And so we end up with just this incredible amount of information. And one of the things that I've discovered in doing jury consulting work where I'm helping people, draft their opening statements and do those things is that as an outsider, it is much easier for me to come in and help people craft their stories in a clear, concise, short way than it is for me to write my own opening in my own trials, because having that outside perspective, it's easier to kind of condense that information. But when we spend years with the case, it's tough because we feel like everything is important.
We don't want to leave any stone unturned, and condensing all that information, that 4 days of testimony, to a 15 and I'll be liberal 20-minute closing is a challenge. And that's probably very, very hard. And the other question I have is there are a lot of rules in every state about what lawyers can do in openings and closings. We have to project what the evidence will show that. We have to use that statement in Maryland before every paragraph we say. And in the closing, we can only refer to actual evidence. How does this storytelling structure, fit with that? Often we think of telling a story as being somewhat fictional in a phrase, but obviously here it still has to fit with the evidence.
Yeah, I think that's such a challenge for lawyers. And I think the actual biggest hurdle that most lawyers have is feeling like they're more constrained than they actually are. There are actually so many things about the rules that give us the freedom to be really creative and do some really cool things in trial. And so I think what I find is the thing that I do in working with lawyers is trying to get them comfortable with actually this does comport with the rules, and I can really go in and be a much more creative human being in the courtroom than I ever thought I could. And some really cool stuff can happen in the courtroom. And the thing that I think is really cool is that when interesting things are happening in the courtroom, judges want to let it happen because think about how bored they are all day long
Right.
in trial if we're just like, Um, so it's we can have a lot of fun and do a lot of really creative, interesting things in the courtroom. And I think it's trying to look at it from a perspective of what will the rules permit me to do rather than what will the rules stop me from doing.
Gotcha. That makes sense. I find this all really fascinating, and having been in courtrooms now for 45 years, uh, it's so compelling what you talk about. And in the last 15 years, I really focused a lot on family law. And boy, is there always grounds for making the other party the villain in those cases. And I suspect the same techniques would work just as well in presenting evidence in to a judge on a divorce case about the other party, and probably even more so because he's really going to love hearing a story instead of someone reciting this witness said that and that witness said that. So while you focus on juries, for all those of you who are listening, I would ask you to explore this further, because you could use it in non-jury cases. You could use it in mediations too. Use the same storytelling. When the judge asks you to do an opening and mediation, instead of dryly reciting the facts, tell the story. So I think there are a lot of different ways where we could use these techniques.
You're so right about that. One of the things that I've really sort of transferred this to in so many ways is it's changed the way I write my briefs, and it's changed the way that I write complaints. So there's, a lot of ways that we can apply these skills to the different areas that we work in.
This is really fascinating stuff. I want to thank you, Keeley, for sharing it with me. And you listen, and I ask all my guests this question, and I'm going to ask you it as well, that I call this the free lawyer, this podcast, because it's about how we lawyers can create more personal freedom in our life. And one way you've done that in your life is to move from the stress and heartbreak of handling jury cases yourself to find your passion in teaching lawyers how to be better trial lawyers. But in your life, what does personal freedom mean to you, Keeley?
For me, I think it's about having the freedom to continue to grow. So one of the things that I found in doing trial work is that you're so busy. There's so much to do all the time. And it's very difficult to find the time to continue to grow and learn and change and, become a new, better version of yourself. And, you talked about this, the idea that, we don't have the time necessarily to train, have, the the more experienced lawyers train the younger lawyers because it takes away from those billable hours. And so for me, it's been finding that freedom to really start to explore new areas and continue to grow my skills and grow also just as a human being.
Well, that's wonderful. And I really like that. There's a saying which I don't agree with. You can't teach an old dog new tricks, because I kind of downsized from my active practice when I was 66. And I've grown and developed so much with my writing and the podcast and coaching. And I found that's where my passion lies. It just took me a little longer to find it than you found yours. But I know I've learned and grown so much in the last couple of years. And we can always learn new things, and we can always chase our passion. So often I hear lawyers talk about feeling stuck in what they do. And my question to them is, what will set you on fire? What will bring you joy in what you do every day? And what I love about your story, not only what you teach, but your personal story, is how you have found what you love every day and you're chasing it. And that's beautiful.
Thank you so much, Gary.
Well, thank you for joining us today, Keeley. A last question I have for you: for those of you who listen and find what you shared fascinating and insightful, how can they best get in touch with you?
So the best way to find me is at my website at winningstory.law. And also, thanks to Gary, I have now found myself on LinkedIn, and I'm trying to be active there daily. So you can find me as Keeley Blanchard or LawStory on LinkedIn.
Fantastic. Keeley, thank you so much. I really appreciate your time today and your expertise. It'll mean so much to all of us. And thank you all for listening. I appreciate you being here today. And as always, please be well, be safe, and be free. Thank you so much for listening to today's episode of the Free Lawyer Podcast. Wherever you are listening, if you enjoyed what I shared, please leave me a rating and review. I would appreciate hearing more about what you like best and what topics you might like me to cover in future episodes. If you are interested in experiencing a more fulfilling and a more successful life, please contact me at www.garymiles.net, where you can schedule a free discovery call with me so I can learn more about you, your challenges, and your dreams. I appreciate each and every one of you, and have a great rest of your day. Thanks to all of you for your support.